After writing the dictation, please press the like, share, comments and bell icon in this channel. Legal dictation at the speed of 100 to 110 words per minute. Get ready. Start. Sri M.C. Chauhan, Learned Senior Counsel appearing on behalf of the Administrator, submitted that Section 7 of the UTI Act 2002 gives effect only to a part of the scheme which must be understood in the background of the larger scheme envisaged by the Act reads as a whole. Under Section 3 of the Act, the statutory successor is the central government and the share capital vests in the central government. Refund of the share capital is to be made by the central government to the contributors named therein. It is for this reason that the central government steps in under Section 4. The undertaking vests in the specified company. The specified undertaking vests in the administrator under Section 5. This is the scheme of transfer and therefore Sections 7 and 18 of the Act must be read harmoniously. He further submitted that even if it is assumed for the sake of argument that the administrator acts as an agent of the central government, that is immaterial because the administrator and the specified company are deemed to be financial institutions by reason of Section 18 of the Act read with Section 4A of the Companies Act. In any event, in this case, the facts are quite clear. The respondents 1 and 2 have used for recovery of amounts due to them and they have not acted as an agent or as a debenture trustee. Sri Rakesh Dwivedi, Learned Senior Advocate appearing on behalf of the UTI Trustee Company herein drew our attention to Section 3 of the Unit Trust of India Act 2002 and submitted that the aforesaid provision refers to the initial capital of the trust. To understand that term, one must refer to Section 4 of the Unit Trust of India Act 1963, which provided for the initial capital of the trust. Section 4 aforesaid provided that the initial capital of the trust shall be 5 crores of rupees divided in the form of certificates, each of which shall be of such face value as may be prescribed and contributed in the manner hereinafter referred. Subsection 2 refers to the contribution to be made by the Reserve Bank of India, the Life Insurance Corporation, the State Bank and the subsidiary banks and other institutions. Section 22 of the 1963 Act provided that the capital of the trust in relation to the first unit scheme shall consist of the initial capital, the unit capital of the said scheme, any reserves created for that scheme, etc., etc. Thus, when Section 3(2) of 2002 Act refers to the initial capital, it refers to the initial capital created under Section 4 of the Unit Trust of India Act 1963. He submitted that under the UTI Act 2002, the initial capital has to be refunded by the central government. Thereafter, Sections 4 and 5 of the UTI Act 2002 Act deal with the undertaking of the trust and the specified undertaking of the trust which vests in the specified company and the administrator respectively. Thank you so much.